The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Morning and welcome to the second remote session of the North Carolina Court of Appeals this morning. I'm Richard Dietz, and joining me on the panel this morning are my colleagues, Judge Hunter Murphy and Judge Darren Jackson. We have one matter to hear this morning. That's number 21-380, Bradshaw versus Maiden. We've confirmed that the parties are ready to proceed, so we'll hear from the appellant.
Good morning, Your Honors. May it please the court. My name is Gary Mauney. I am one of the attorneys representing the plaintiffs in this action. The trial court committed reversible error in this case when it collapsed all of the claims in the complaint, including claims of negligence, allegations of gross negligence, basically into a single fraud standard, meaning the trial court essentially required us all along the way to demonstrate actual fraud, knowing conduct in this case, when intentional conduct was not what was needed to surmount both the 12B6 motion at the beginning of the case and the Rule 56 motion at the end of the case. Plaintiff's complaint is replete with allegations of negligence, Your Honor, and gross negligence. And then when the court attempted or did hold us to a fraud knowing standard, that's not the standard even for gross negligence, Your Honor. There's a recklessness component to the elements of gross negligence, which the court disregarded. And then, Your Honors, we even demonstrated actual negligence, and we'll show you some exhibits in a minute that illustrate that SS&C knew there was a fraud going on with the fund that's at the heart of this action, knew that the statements that it was sending out to my clients every single month directly by email, knew that those statements were false after a point. For a few years, about 3 years, they were not collecting documentation. SS&C, the defendant, the accountants in this action, they were negligent. And then in 2009, the matter took a point where the accountants actually knew that fraud was taking place. And we'll show you a couple of exhibits this morning that illustrate that. There's no question.
For your general negligence claim, where does the duty originate in under your theory of that negligence claim?
There are two sources of that duty, Your Honor. The first source is our case that we've cited, Penix, which is also cited by other cases in our brief. In Penix, the case says that if you have a contract, in this case, SS&C and the fund had a contract, and through that contract, they were obligated to provide these capital statements to my clients every single month. Penix says that because of the existence of that contract, which causes a duty to send the statements out to my clients, that once they have that duty and they start sending those statements out, they had the obligation to use reasonable care, ordinary care when they were doing so. That's basically the negligence standard. The second negligence standard in this case is the negligence standard for negligent misrepresentation that was first enunciated in the Raritan case from the state Supreme Court here. And in that case, the state Supreme Court adopted Section 522 of the restatement. And in the restatement there, it is entitled Information Negligently Supplied for the Guidance of Others. And that's what was happening here. Every single month, SS&C's accountants sent out these statements to my clients. And then there became a point where there is no doubt in the record on the evidence, abundant evidence, that SS&C knew or should have known that what they were sending to my clients and what they had been sending for at least 3 years as of 2009, that those statements were false. And my clients, Your Honor, they were investors in a relatively small hedge fund based in Charlotte, North Carolina. We had a grocery store owner in the investor group. We had retirees. We even had a school teacher in the group. And if I could, Your Honor, I'd like to share a document with you that I think...
Mr. Mauney, before you move on to that, let me ask a question just as follow up with Judge Dietz's question regarding the creation of the duty. I just want to make sure at no point below did you advance any theory that Lauren Locke, the person that came in when Nedfield was on maternity leave, that her actions constituted a voluntary undertaking in any duties that arise when somebody takes on a voluntary undertaking, correct? that
No,
was not
it's
raised below?
I'm sorry, Your Honor, but it was raised below. It's in the complaint. Certainly, that was part of what we've alleged here, is that there was a voluntary undertaking here when SS&C's accountants, all of them, Ms. Needfeld, who was the primary accountant, and then it's a Mr. Locke. I know it's a name that sometimes women have, but Lauren Locke, her supervising accountant, came in when she was on maternity leave and took over. So yes, we allege that there was negligence on behalf of all of the accountants who were sending out these account statements.
I'm sorry, but nothing where there's a voluntary undertaking to create a duty when Locke started asking for the documents then in mid-July 2009. That wasn't argued as a separate creation of a duty or anything like that, correct?
We argued that all of the accountants, based on sending out these account statements, had a duty. They all worked for SS&C. They were all agents of SS&C, and they had a duty to use reasonable care when they were sending these documents out to our clients. So during Mr. Locke's tenure, he was the one responsible for the statements that are at the heart of the complaint and that we've alleged in the complaint. So absolutely, he was performing his duties pursuant to a voluntary undertaking, meaning the one that was created by the contract between SS&C and the fund. Our clients never saw that contract. They were not parties to it. It's just that this duty gets created once you're performing under that contract and you're sending the statements out to our clients. And Mr. Locke was one of the ones sending out those statements. So absolutely, we did. And by the way, Your Honor, you have to remember, we probably did have this particular document at the beginning of the case, but these are things that you've gotten through discovery, but we allege that all of the accountants that were creating these statements on behalf of SS&C were negligent. I can show you, Your Honor. So here's the, can you see this, Your Honors?
I cannot really make it out. If you have a way to make that full screen, that may be helpful.
I will. So as we said earlier, in 2009, let's see if I can make this a little easier to see. In 2009, Your Honor, Ms. Needfeld goes out on maternity leave. And what's supposed to happen is there's supposed to be documentation in the file, meaning share certificates, checks, bank statements, and that sort of thing in the file already to demonstrate that the fund actually owns what is listed in the general ledger and then what is then produced into the account statement. So you can see here that Mr. Locke looks in the file and sees that there's nothing there. And so what he says is, Steve, who is the fund manager at issue here, I don't think we have finalized documents for your restricted investments. And the restricted investments are the private investments that are at issue here. And the fund manager immediately knows what he's talking about. He says, you mean like certificates and docs describing my ownership or what? And that's exactly what's absent here. So we're 3 years into the fund where the SS&C has been sending out these statements to my clients for 3 years. We're in July of 2009. And Mr. Locke says back to the fund manager, any certificates or finalized docs showing ownership, proof of ownership. And so what's happened here is that every month, the fund manager has just been emailing and saying, I bought this or I bought that, and I have, and without the accountants at SS&C ever asking for share certificates or anything to document the ownership. And you can see the fund manager says, we'll take a little time to track down some, when presumably they would have already had it, or you would certainly hope at this point, hey, here's my share certificate showing that I actually own the thing that you've been accounting for 3 years. And then you can see at the top of the email where Mr. Locke says, I will have the accounting finalized tonight. There's just no question about whether or not these things were absent. So then what happens is they don't come in. And a month later, Mr. Locke, as you can see here, he writes back and he says, any luck on gathering the backup for the away investments, meaning these restricted private investments that are at the heart of the case. And what happens then is the fund manager says, oh yes, back up, forgot. He had not forgotten. And so what happens is later that day, the fund manager faxes Mr. Locke, and this is an example of what he sent over, a share certificate for 500 shares of Blue Earth Preferred, Series C. On the books of SS&C for the fund at this time, which are then translated into the capital statements that my clients get from SS&C directly by email every month, you can see that this is for 500 shares. And what SS&C is carrying on the books at this time, based only on the say-so of Mr. Maiden, are 1,450,000 shares. So as of July of 2009, they're carrying 1.4 million shares on the books, and they can see from this share certificate, Your Honor, all he can show is a certificate for 500 shares, more than 1.4 million shares off. They know at this point that what they've been sending out for 3 years is wrong, and they also know that every statement that they send out that's based on that information after that is wrong. That is all we have to show, Your Honor, on Rule 56. Is there a disputed issue of material fact? The court is supposed to be drawing all of the inferences in our favor. And you look at that and you say, how on earth have we been sending out statements based on 1.4 million shares? And now we know all the fund manager, which we should have known from the very beginning, all the fund manager can show us is 500 shares. And yet they continue to do that month after month. And then as the tax season comes in 2010 for the fund, the tax accountant for the fund says, hold on your holdings report, and the holdings report is an accounting document created by SS&C. On your holdings report, we see a position at $1.45 million market value, and then the share value was, the number of shares was 1.4 million as well, but zero cost, Your Honor. How on earth do you get an investment worth millions of dollars, and this is just an example, that you claim to have obtained at zero cost? So the tax accountant says, what is the nature of this security and how was it acquired?
Mr. Monty, let me ask this real quick regarding the zero cost, because there's so many moving pieces here. And one thing I do notice, you've got some other documents you're preparing to show. I just want to make sure none of those have any account numbers or social security numbers on them. I think at this stage of the hearing, just make sure nothing's exposed there. But with the zero cost booking, on page 28 of the appellee's brief, it explains where there's other incidents of zero cost booking which were appropriate. So why would it not have been reasonable for SS&C to understand that this also was a zero cost booking that may have been appropriate? To me, I agree. When I first read your brief, like my jaw was on the floor about that, but then I see this, at least somewhat of a statement that this doesn't necessarily mean fraud, that this happens on occasion. I don't understand it, and I've got a degree in economics, but explain to me why either the appellee's wrong on page 28 talking about zero cost booking, or why it matters here different from why it didn't matter with these other situations.
Your Honor, because those are the lawyers on the other side making those arguments. They didn't submit any expert evidence at Rule 56 about that. Those are just the lawyers saying that. We have two experts, at least two experts, Mr. Bellinger in the record and Mr. Buckles, who is the head of accounting over at NC State, and now he's the dean of the School of Business over there. They testified that there's nothing appropriate about a zero on for a multi-million-dollar investment that you're recording on the books, that the minute you see that, you should be assuming that it's fraud. In the United States, I would suffer to guess that there are no hedge funds where they've obtained investments at zero value, But we have evidence in the record from experts, not evidence which is not competent, coming from the lawyer saying, oh, that's okay, nothing to see here. That's a lawyer making that argument who's an advocate in this case, not an expert. They had none. We had at least two. We had three, but two that spoke to this point that are in the record. You can see that Ms. Needfeld on this exhibit is saying, I don't see a corresponding cash flow for this. He claims it was in '08. And then she says, because she knows that there's something wrong, that she will flip the applicable cost off the Blue Earth, that's a common stock holding, to the segregated C shares, which is an altogether different investment. So she knows there's something wrong, and she volunteers to flip it. You can see here.
So, counsel, I want to just go back and ask you one thing. So, just to clarify, because I think with Judge Murphy's question about the zero cost booking, the observations in the brief, which of course are just legal arguments, though, did have a record citation. So there are documents in the trial record, are there not, where the cost was zero for the debt acquisition, or do you dispute that?
On the defense side, Your Honor, the evidence that they submitted they have no expert testimony for what they're saying. That is the lawyer making that argument. On our side, we had experts saying that the zero cost was highly inappropriate, deviated from the standard, was evidence of fraud. So those are just the lawyers saying on their side, saying, hey, there's this explanation. Oh, yeah, that could have been okay. But as you know, that if someone shows up and claims to have a multi-million-dollar investment, in this case, they were supposed to be collecting documentation to show that. That's the essence of our case. Our experts have so testified. Their internal records and policy said that they were supposed to be collecting that information. And we're in Rule 56, Your Honor. All of the inferences are supposed to be drawn in our favor, and that is a question of fact. Did they know or should they have known? And we presented evidence that both of those elements were met, and we showed it in spades. On this document that's on the screen right now, this is where Ms. Needfeld actually flipped the basis from one side to the other. That's a whole nother aspect of the active participation in the fraud. When the tax accountant says, we don't see any payment for this, and she says, no problem, we'll flip the cost from another investment over to this one and make it appear that it was actually paid for. You can see, Your Honor, that she didn't even use the $500,000 that the fund manager told her. She picked an uneven number, and then she doesn't put it in the same period as the event that the fund manager claimed, which we dispute. Again, another disputed fact. But you can see she books it at year-end 2010 in order to satisfy the tax accountant. This is evidence of an active participation in a fraud by these accountants. Here's another one. From Ms. Needfeld, the way I have it represented, you received this security free of cost. Answer, yes, free of cost completely. And she books it. And here's another example. She can see that money is going out of the fund's brokerage account. Here are these amounts, $155,000, $100,000, $50,000, and so on. And she has this document in her possession at the time she's asking about these cash flows. And she can see from the documents in her possession, and again, we have expert evidence that says, you see this, you know there's a fraud, and it should have all stopped by this time. This is in April of '08. She asked the fund manager, because she could see this, where is this money going? And he tells her it's going to things like Blue Earth, another investment called Kit Media. When she can see from the document in her possession, you can see there's an SS&C bait stamp at the bottom here. The $155,955 that's here, she can see that it's going to an account, basically going straight to Mr. Maiden's account at Bank of America, not where he told her. This is an issue of fact, Your Honor. Did they know or should have known? Yes, absolutely. Here's $155,000. She can see it's going straight to Mr. Maiden at his Bank of America account. And this is a document that the accountants had, and they were looking at every month when they did this. This is a document from the criminal case. There's nothing private about this. The account's not live anymore, but this is what we got from the fund manager and you can see the money landing in his account. At the end of the day, right before the fund collapsed, Your Honor, SS&C did not have share certificates for any of these assets that you see here. It was almost $12 million. SS&C had nothing to show that matched these. And you can see they're carrying, remember, Mr. Locke finds out that the fund doesn't own 1,450,000 shares in 2009, and we're in 2012, and they're still carrying 1.4 million on the books. They're taking all this information, they're rolling it up, and they're sending it out to our clients. And you can still see here where they flip the basis, the 473,000 onto this investment to make it appear that it had actually been paid for. If there was no issue about it being paid for, why didn't Ms. Needfeld just say, oh, that was zero, and Steve told us it was zero? Who cares? But that's not what she did. She flipped the basis unlawfully from one investment to the other. And you can see here that it happened, and that they're carrying amounts on the books that, according to their own records, are at variance with what they actually had. When you see that what you've got on your books is either you asked the fund manager for it or you were supposed to obtain it because there was a documentation requirement, which is a fundamental rule of accounting, you're at variance with GAAP. Our experts said there is absolutely no accounting standard that would allow you to put these things onto the books and records of the fund without having appropriate documentation. And appropriate documentation, our experts testified, at worst creating an issue of fact. They testified that an email from the fund manager making bald-faced claims that I bought this or we own that, that is highly inappropriate. And when you're booking that information without having a share certificate, without collecting the bank statements to see the cash flows, that you're actively participating in a fraud. And even if this was not a negligence case, if for some reason we were obligated to prove fraud, which we were not, then by 2009, when they ask for this documentation and they don't get it, and they know that, just illustrating by the 500 share certificate for Blue Earth, they know that 1.45 million is completely false, Your Honor, and yet they continue to send statements out based on this value. And we're arguing, our argument is based on, number one, they were supposed to obtain the documentation. That's a basic accounting standard. That's negligence. Number two, under Raritan, when they were sending out information to our clients that was negligently created, we meet the standard under the restatement 522. Are you negligently sending out business information that other people are relying upon? And absolutely, they were doing that, Your Honor, and our experts testified to this. And again, SS&C presented no expert testimony in a case about accounting standards, or at least in part about accounting standards, at summary judgment. Raritan, by the way, under the restatement, doesn't even require it to be accounting. It is just business information. If you're supplying business information that you know or should have known is false, then you are liable under the Raritan negligent misrepresentation theory. And then finally, on the fraud claim, which you could couch the fraud claim under our gross negligence claims, which the trial court sort of eliminated the back half of the gross negligence standard. There's the willful part of gross negligence, and there's the wanton part of gross negligence. And the wanton part says, were you reckless when you did something? Did you do something recklessly and in disregard of the rights of others? And in this case, we have plentiful evidence presenting issues of material fact that SS&C's conduct in this case was reckless. And every month, when our clients would get these statements in their mailbox and they would show value in their fund, they had every reason to believe that SS&C, purportedly a reputable accounting firm, that they had used reasonable and ordinary care when they produced that information. And for sure, they had a right to believe that it was based on underlying documentation and the appropriate GAAP standards. And Your Honor, I believe I'm about at my 5-minute mark. And I will, yes, Your Honor.
On page 27 of the appellee's brief, they list out, some suggestions of why they're not involved with it. And they say SS&C was paid on a fixed fee basis and had no motive, financial or otherwise, to further Maiden's fraudulent scheme. That doesn't seem to match up with what you've alleged in the, I guess, the amended complaint at record page 196 to 197, paragraph 140, that there is a fixed amount and then an increased percentage of assets as the fund total assets grow. Is that correct?
So it is in the complaint, Your Honor. So what happened here is they were paid eventually about $50,000 a year to do the accounting. And we believe that, or the theory of our case is that through about 2009, there was negligence, and there was negligence in the preparation of the reports. And then only after 2009, there was fraud. Yes, if the account got big enough, then what would happen is they would get paid based on a percentage of the assets. What was happening at or about the time that Lauren Locke found out that there was fraud occurring in this and continued to produce the statements anyway, was that SS&C was going public. They advertised that they prevent the Madoffs of the world from happening. And so right here in Charlotte, North Carolina, while they're advertising to everyone as their reason for existence, hey, we prevent fraud from happening. It's happening in the exact way that Madoff did it through his accountants. And that's why, Your Honor, I mean, we don't have to prove motivation other than by circumstantial evidence if motive is not an element of any of the claims, really. But if you're asking why would they do something like this, we have plenty of accounting cases where the amount that the accountants might have even charged, let's say that they do your tax return and you're a millionaire and they charge you $1,000 to do your tax return. If it's prepared inappropriately or they conduct themselves fraudulently, they're liable for the harm that they cause. And at the very least here, we're at Rule 56. These types of things are for the jury to decide. They were not for the trial court to decide. That's the standard. We're not having to prove our whole case here. We have to show one issue of disputed fact. And we would say to Your Honor, we have showed abundant issues of material fact and no entitlement by this defendant to judgment as a matter of law. Thank you.
All right, thank you, counsel. We'll hear from the appellee.
Good morning, Your Honors, and may it please the court. My name is Jeff Recker with the law firm Paul Weiss, Rifkin, Wharton, and Garrison, and I represent defendant SS&C Technologies. I want to respond in a minute to the arguments we heard from Mr. Monty, but let me take briefly a step back here and put some of this case in context. This is a case about a fraud committed by Steve Maiden. He formed his own hedge fund in 2006 and several years later sought to make up for what were legitimate investment losses by inventing fictitious assets. Maiden's not in this courtroom, and he's not in this courtroom because he pled guilty to securities fraud. He was imprisoned and he was subject to a default judgment below. Now, while plaintiffs have a judgment against Maiden for the full amount of their alleged losses, I submit that they're wrongly trying to shift responsibility for Maiden's misconduct to SS&C. Court below dismissed or granted summary judgment on each of plaintiffs' claims against SS&C in two detailed opinions, carefully considered over nearly 70 pages of opinions, all of the evidence in each of the arguments we heard about from plaintiffs this morning. From our perspective, there are two basic reasons why the decisions of the court below are correct and should be affirmed. First, there is a failure of proof that SS&C knew or even suspected that Maiden was lying to SS&C or committing a fraud. The absence of any genuine dispute on that issue, I submit, is fatal to plaintiffs' gross negligence claims and each of their other claims, all of which, contrary to what we heard from plaintiffs' counsel this morning, do require a showing of knowledge. Second, plaintiffs' arguments to avoid that failure of proof, that SS&C was subject to a tort duty to uncover Maiden's fraud by obtaining and reviewing third-party documentation, that argument fails as a matter of law. So I will address each of those issues, but before we get into the evidence, I did want to address some of the very basic facts about the role that SS&C actually played in this case. SS&C was retained by the fund controlled by Maiden, to act as a fund administrator. What does that mean? It means that SS&C played a non-discretionary administrative role in which it maintained the books and records of the fund based on the information that was reported by Maiden to SS&C. It wasn't an auditor. It didn't undertake to verify whether the assets of the fund were real or what Maiden was telling SS&C was true. SS&C agreed to perform discrete tasks, and the parties' contract explains that quite clearly, as the trial court recognized and discussed in detail. We do have a few excerpts from documents in the record that I will try to put on the screen if I can execute this. You hopefully should be able to see here the discrete tasks that SS&C agreed to perform. Now, each of these tasks required SS&C to prepare books and records for the funds and reports based on those records. Now, the contract was equally clear what information those books and records would be based on. Information supplied by Maiden or third parties he designated. That's the passage of the contract that I just hopefully brought up on the screen. It says the books and records described below will be based on the information SS&C receives from the fund or its management and from third parties the fund designates. It says SS&C will be responsible for maintaining a record of transactions based on the information supplied. Now, the only one of these discrete tasks that were on the screen a moment ago that brought SS&C into contact with the plaintiffs, and Mr. Monty mentioned these as well, it's the delivery of investor capital statements. We have an example of one of those on the screen. And the undisputed record shows that every month, before any of these statements were sent to any plaintiffs or any other investors in the fund, SS&C circulated a draft capital statement to Maiden. And he confirmed every month that it accurately reflected the fund's financial position. These statements likewise disclosed to investors, including the plaintiffs, that the performance figures in these statements were preliminary, unaudited, subject to change. Actual results may vary. Now, there's no question that in hindsight, the fund's financials were inaccurate. Maiden reported false information to SS&C to be recorded in the fund's books, even while he confirmed again and again that the capital statements were accurate. But SS&C is not responsible for a fraud that it did not commit and about which it did not know. Now, I want to focus on plaintiffs' gross negligence claims. They pled other claims, and each of their claims requires some showing of knowledge. But gross negligence is I think, where the focus is, and those are the causes of action that plaintiff asserted in their complaint. And
before you get too far from the ASA and the agreement,
sure.
Yeah, there's this language that's quoted and cited as being 418 in the doc exhibits that SS&C shall keep at its premises books, records, and statements as may be reasonably necessary to document the transactions recorded by us, meaning the fund, on behalf of the fund. Is this language just not mean anything then, if there's no requirement to have any documentation?
No, Judge Murphy. And in fact, I think we have that language. I just hopefully brought it up on the screen. It does have meaning, although it's not the meaning that plaintiffs ascribe to it. What this refers to is not what documentation should be obtained. We saw that a moment ago. That's information supplied by Maiden and management. This provision, in our view, and as the trial court found, addresses what information should be maintained. It's a document preservation provision. It talks about what documents SS&C will keep. And we saw a moment ago, right, on this passage right here, that the documents that SS&C was to obtain, the documents on which the books and records will be based, are information SS&C receives from the fund or its management. And let me also be clear about what plaintiff's documentation argument really is. It's not that SS&C didn't have documentation for the transactions that it recorded in the fund's books and records. It did, and there's no dispute about that. It may have been a brokerage statement. It may have been an account statement. Mr. Monty displayed one that SS&C had in its possession. It may have been information we received from Maiden himself through emails or other correspondence. Plaintiff's argument isn't that there was an absence of documentation to record the transactions that SS&C in fact recorded. It's that SS&C was under an obligation to go obtain third-party documentation, independent verification of what it was being told and what it was obligated to rely on from Maiden. That's their argument. And we submit that the trial court below correctly found that there is no duty to obtain third-party documentation. Now, I want to talk for a moment, if I could. Mr. Monty mentioned Pinnock's. He talked a little bit about their arguments about the circumstances in which the duty in this case allegedly arises. They claim, and have claimed since the outset, that the duty in this case arises out of the contract. And what Pinnock says, plaintiffs argue that Pinnock supports their position. I submit it supports ours. Pinnock has a simple, and I submit uncontroversial proposition, which is a contractual term does not displace a common law standard of care. There's no dispute about that. We have been talking in this case, it's in our briefs, about the gross negligence standard of care. That's a common law standard of care. The problem is plaintiffs miss the threshold question, and that's one of duty. What is the obligation that has to be discharged under a common law standard of care? And Pinnock answers that question too. It says you have to discharge under a common law standard of care. Here, that's gross negligence. You have to discharge under a common law standard of care the thing agreed to be done. And what SS&C agreed would be done with Maiden is that SS&C would maintain a record of transactions based on the information that was supplied to it. So the argument made by plaintiffs, there's an additional tort duty that's contrary to the terms of the contract, I submit doesn't work under Pinnock's, which is the case they rely on. The law doesn't say to a contracting party, you've agreed to a discrete set of obligations. But actually, surprise, we're going to impose a tort duty where you are obligated to undertake different services that you didn't agree to supply in your contract and which you didn't negotiate with your counterparty to actually perform. That, I submit, is not how tort duties work, whereas here you have a tort duty arising out of a contract. But let me focus now on what I called their failure of proof. And it is the case in our view that plaintiffs have to demonstrate knowledge. As I said, these are gross negligence causes of action. There is no simple negligence claim in their complaint. And the North Carolina Supreme Court in Yancey made this very clear. Gross negligence connotes intentional wrongdoing. It is an act done purposely and with knowledge that the act is a breach of duty to others. That is, it's a conscious disregard of the safety of others. And what that means is plaintiffs have to show that SS&C knew Maiden was lying. They have to supply some genuine dispute of fact that SS&C undertook a purposeful act with knowledge of its consequences. It's not enough for them to say that SS&C should have known. I mean, we don't think the evidence in this case even rises to that level, but that's an ordinary negligence theory. It's not a gross negligence theory. And the simple fact is, after 5 years of discovery, this case lacks any of the evidence that one would expect to see if a fund administrator knew about and participated in a Ponzi scheme run by one of its clients. There's no testimony from Maiden saying SS&C participated in his fraud or assisted him by reporting false information. There's no communications between SS&C and Maiden coordinating an alleged conspiracy. There are no internal emails or documents reflecting some concern or awareness on the part of SS&C that Maiden might be lying. There's no warnings sent to SS&C by securities regulators, by investors, that the fund might be a sham. Nobody knew about Maiden's misconduct until he was charged by the U.S. attorney. And there's no evidence of a kickback or other benefit to SS&C employees. You know, Mr. Monty was asked this question earlier. There's also no motive here. I mean, they don't even attempt to explain why SS&C, a significant fund administrator, would participate in a fraud operated by Steve Maiden. SS&C was not paid based on the assets in the fund. It was paid on a fixed fee basis. There's no incentive here and there's no motive. And in fact, all of the actual evidence in this case, in our view, it contradicts what plaintiffs need to show. All of the SS&C witnesses testified consistently, there's no dispute about this, that they had no idea Maiden was operating a fraud. Maiden acknowledged repeatedly in his criminal proceedings, under oath, that he lied to and deceived SS&C in the same way that he deceived his investors. So what do plaintiffs point to? And Mr. Monty mentioned a few of these items this morning. They're contained in their brief, and I'd like to just tick through them quickly. But first, I do think it's worth putting this in context, because SS&C prepared more than 53,000 pages of accounting schedules. And from my perspective, that helps put into context what plaintiffs are complaining about here, which is a handful of line items that they picked out in hindsight. Mr. Monty spoke this morning about the Bank of America account, that SS&C had information showing that funds were being transferred from the funds account to the Bank of America account. Now, that's an account held in the name of the fund's general partner. But the evidence plaintiffs rely on doesn't raise any inference that SS&C in fact believed that those transfers were for improper purposes. Maiden told SS&C again and again what the outflows were for. Things like tax payments, fees for tax accountants, fees to the North Carolina Secretary of State. There's nothing sinister about that. It's certainly nothing that could demonstrate actual knowledge on the part of SS&C. And from my perspective, their theory really doesn't even make sense. I mean, for what reason was Maiden inventing a complicated fiction in which he was inventing legitimate purposes for these funds transfers if, as plaintiffs have to show, SS&C actually knew that Maiden was lying? Now, zero cost accounting. There were a handful of investments held on the books at zero cost, but there's no dispute here that Maiden in fact received legitimate investments at zero cost. Mr. Monty said this was lawyer argument. It's not. We supplied and cited in our brief record evidence showing third-party brokerage statements for the fund where Maiden was holding legitimate assets at zero cost. It's not lawyer argument, it's in the record. And in fact, the trial court made that finding. We made that argument in our brief, and I read plaintiff's reply brief with great care. They don't respond and supply any record evidence saying that that's not the case. And the other point I would add with respect to zero cost accounting is while plaintiffs try and spin it as something sinister, it's simply not. I mean, you can imagine several scenarios in which you could receive securities at a zero cost. You could have a dividend for a company in the form of stock. You don't make a cash outlay for that sort of distribution. You could receive as part of a settlement, and this is what Maiden claimed. You could receive securities at zero cost. So the zero cost accounting argument, I submit, doesn't tell you anything about whether SS&C in fact knew that Maiden was not telling the truth. Now, Mr. Monty also mentioned this morning change of investment basis for one of the fund's investments. We talk about this in our brief. I won't belabor it, but the facts here are not in dispute, the actual facts. Maiden reported to SS&C that he held two different share classes in Blue Earth, public shares and private shares. And there was a time when SS&C included both the private shares and the public shares on the same line item amongst its schedules. When they later segregated those two different investments, the cost to acquire the private shares weren't moved along with the asset. The costs, the underlying costs that we were told by Maiden he incurred in obtaining this investment, the underlying costs were on the books the whole time. They were just on a different line item. And when SS&C realized, and there's no dispute about this, when they realized that the cost was on the wrong line item, they moved it in 2010. again, I think it's directly inconsistent with the notion that SS&C actually knew that Maiden was perpetrating a fraud. So when they talk about flipping the cost basis, while they try and characterize it as something sinister, it's really just fixing a mistake that SS&C recognized. It didn't change any of the reporting to the plaintiffs in this case because the underlying costs were on the books the whole time. Again, a point we made in our brief, plaintiffs don't respond to that with any record evidence in their reply. Now, another point they focused on in their briefs is a transaction in which SS&C reduced the cost basis for another investment in Kit Media, a company called Kit Media, following a 35-to-1 reverse stock split. Again, the evidence is undisputed, I submit. That was the result of a mistake. When there was a 35-to-1 stock split, you're supposed to take down the number of shares. SS&C inadvertently took down the cost along with the number of shares. But again, it actually undermines plaintiff's theory that SS&C was somehow cooking the books together with Maiden. And here's why I say that. The investor capital statements, we saw one earlier, don't actually report to the plaintiffs in these cases what the cost basis for any investment is. They report asset value on a month-over-month basis. So the errors that plaintiffs point to don't actually even make their way to the plaintiffs in this case. And they're certainly not consistent with the theory that SS&C actually knew about Maiden's fraud. So what do plaintiffs say to try and get around what I've characterized as a failure of proof? They make two principal arguments. One is that they somehow have mere negligence claims in this case, even though they didn't assert mere negligence claims in their complaint. The other is, as we spoke about a moment ago, that SS&C supposedly had an obligation to verify Maiden's investments by obtaining third-party documentation. Let me start with the first argument, and each of those arguments, in our view, was appropriately rejected by the trial court. And the trial court was correct that there was no notice of a simple negligence cause of action when the complaint doesn't plead one. The complaint pleads gross negligence, and it pleads grossly negligent misrepresentation. And the record here, I submit, is much worse than just that. And we cited excerpts in our brief. And I'd urge the court to review plaintiff's motion to dismiss papers. They said in those papers, time and again, that their claims survive under Yancey because SS&C knew and actively participated in Maiden's fraud. They said to the trial court, these are not should-have-known claims. We're not bringing should-have-known claims. We're not accusing SS&C of ignoring potential red flags. Our complaint says that SS&C actually knew that Maiden's claims were false. Those are the causes of action plaintiffs brought, and that's what they set out to prove. The trial court then issues an opinion in 2015 that analyzed plaintiff's gross negligence claims. It said these are each of the claims that the plaintiff brought in their amended complaint in this case. And it dismissed plaintiff's gross negligence claims in part, the principal holding of which was that plaintiffs could not assert a red flags or should have known theory because the gross negligence claims they brought in their complaint couldn't support that negligence theory. The plaintiffs never came back and said, wait a minute, judge, we actually have mere negligence claims. We read your opinion. You said we only have gross negligence claims. We actually have mere negligence claims. They never did that. Instead, they went through 5 years of discovery on mere negligence, only to raise in opposing summary judgment they supposedly had mere negligence claims that are not pled in their complaint. That type of tactic, I submit, is deeply prejudicial. We went through 5 years of discovery in this case based on the causes of action in plaintiff's complaint. But I do think, the fact that plaintiffs now have pivoted after discovery to asserting that they have simple negligence claims is, in my view, a telling indication that the evidence fails to support the gross negligence claims that they in fact asserted in their complaint. Now we spoke a moment ago about the duty argument. And one case I did want to focus on, and we mentioned this in our brief, is a decision by this court in a case called Hoisington. And Hoisington involved negligence claims brought by a mall employee who had suffered an assault in a mall parking lot. That employee brought negligence claims against a company that provided security services to the mall. And the court held that in evaluating the scope of a tort duty to a third party to the contract, the court must look to the contract. That's the starting point for the analysis, is to look to the contract. And the court found there was no duty on the part of the security firm to protect the employee, the mall employee, because the contract required only that the security firm maintain high visibility. That was its contractual obligation. And the court said, in our view, that we're not going to impose an additional tort duty on top of what the contract says. Yes, you have an obligation to discharge under a common law standard what you agreed to do in certain circumstances. They are to provide high visibility. But we don't say, oh, well, you're a security company, and therefore we're going to obligate you in tort to something different than what you agreed to in your contract by saying you have an obligation to supply security services writ large to everyone you come into contact with. That's not the case. That's not the holding of Hoisington, and I submit it's instructive here. So, the other point I wanted to make, Your Honors, is, we heard a lot from Mr. Monti about accounting, and whether SS&C was an accountant and whether there are asides in emails about accounting. I submit it doesn't matter whether or not SS&C is deemed an accountant or any other terminology you might choose to pick. The fact is, as a matter of law, if you look at cases like Pinnock's, the duty arises out of the contract and what was agreed to be done in the contract. And here, as we've seen, the contract says the books and records are to be based on the information supplied by Maiden. That's exactly what SS&C did. And I will say just for a moment, we also heard from Mr. Monti, and if this is in their briefs, they talk about GAAP accounting. Again, same answer. You don't get to GAAP accounting because the only reason they make an argument about GAAP accounting is in service of, I think, what Mr. Monti termed the essence of their case. It's in service of the argument that GAAP accounting required third-party documentation. Now, we dispute that, but again, it doesn't matter. Mr. Monti says, SS&C didn't present expert evidence on summary judgment. Of course not. This is a case about undisputed facts. And it doesn't matter what GAAP required for two reasons. One is GAAP is not mentioned in our contract. SS&C didn't agree to supply GAAP accounting. And insofar as plaintiffs are arguing that GAAP accounting requires third-party documentation, that's directly inconsistent with what the contract actually says with respect to the source documents that should be obtained. The second reason is, we went through this in our brief, so I'm not going to belabor the point, but the only place in the record where plaintiffs find a reference to GAAP accounting is in the partnership agreement between Maiden and the investors in the fund. SS&C is not a party to those documents. They don't bind SS&C. But what the partnership agreement does make clear is that the documents prepared and sent to SS&C, or sent by SS&C to the fund's investors, were not to be obtained or were not to be prepared using GAAP accounting. There are two types of documents in the partnership agreement. that are supposed to be prepared using what the agreement terms GAAP as a guideline. Those documents are audited financial statements. SS&C is not an auditor. It didn't prepare those statements. And net profits and losses as of year end. SS&C didn't prepare those statements. SS&C prepared what are referred to in the partnership agreement as unaudited monthly reports. Those are not subject to GAAP as a guideline. So the theory, we would submit that the theory fails, even on its own merits. There is no source obligation for any GAAP accounting by SS&C in this case. One final point, Your Honors, and I'm happy to answer any questions, but I did want to answer, where Mr. Mauney, I think, started, which is on the emails that were exchanged by Mr. Locke asking for some fund documentation. Again, the trial court reached this conclusion, and we share it. Those documents don't indicate any actual knowledge on the part of SS&C. SS&C asked Maiden for certain documentation, but the undisputed record evidence, the undisputed testimony on that issue is that those requests were made because one of SS&C's tasks, one of the discrete services that SS&C agreed to supply to the fund is to coordinate with the fund's auditors in connection with the fund's audit. It's the last bullet on the passage we have on the screen. The requests for documentation, the witnesses consistently testified, were made so that those documents would be available if and when an auditor wanted to see them. They weren't requests for SS&C to perform the work it was contracted to perform in maintaining the books and records based on the information supplied to it. And again, there's no evidence that anyone from SS&C actually appreciated that Maiden was lying to them. So with that, Your Honors, unless there are further questions, I'm happy
I want to
rest.
follow up regarding the partnership agreement that obviously SS&C was not a party to. In the reply brief, the plaintiffs point out that testimony of SS&C's agent was that they're supposed to follow what was written in the fund's LPA agreement, which would be to be determined on the accrual basis of accounting using GAAP as a guideline. So if there's evidence that your client believed they were supposed to be following the LPA agreement, why is GAAP and its requirements not part of the underlying agreement SS&C was supposed to be following?
Yeah, well, first, Your Honor, I think that testimony excerpt is taken out of context. I think the testimony is pretty specific and consistent that SS&C wasn't supposed to be applying GAAP in the work it was performing for the fund. That is, preparing the backup books and records of the fund based on the information supplied to it. I think that's consistent. Certainly, some SS&C witnesses were aware of what the partnership agreement said, that GAAP was the accounting methodology that the fund would ultimately use. But where that comes into play is where the fund prepares audited financial statements. That's why, SS&C employees were anticipating doing the work that they were contracted to perform, which is coordination with the fund's auditors. And again, I made this point earlier, but just to finish the thought, I don't think the GAAP accounting argument made by plaintiffs really makes a difference at the end of the day. Because the only reason they make the argument they make about GAAP is because they say GAAP imposes a third-party documentation standard. But we know, based on the plain language of the contract, that SS&C did not agree to obtain third-party documentation, and instead it was obligated to base the books and records of the fund based on the information supplied to it. And that's what it did. And Judge Murphy, you asked Mr. Mauney earlier on about whether there was any argument below about a voluntary undertaking. There's not. I have not seen any argument by plaintiffs either on appeal or at summary judgment that there was some sort of voluntary undertaking, a new duty that arose based on what someone at SS&C asked for or did. That's not an argument that they made below on summary judgment. It's not an argument they made on this appeal. Their theory, as I understand it, has long and consistently been the duty that SS&C has, in their view, arises out of the contract, because the contract is the only reason why SS&C had any contact with the plaintiffs or the investors in this case. But for that contract, SS&C would not have had any interaction with those plaintiffs or investors.
Thank you, counsel.
Thank you.
Any rebuttal?
Yes, Your Honor. And may I share, if you could. Your Honor, you're hearing a lot of facts argued right there. And you're being basically asked to not believe your eyes. You heard, oh, there's no document that says anything about GAAP. Here's Miss Lawson, Marianne Needfeld, she changed her name after she got married, saying, per GAAP standards, I will need to record these when I finish the December month end. They knew they were obligated to GAAP standards. They have no expert evidence. Our experts testified they were obligated to obtain documentation. You saw in the contract, even though the contract, our clients were not signatory, it exemplifies the standard. You saw the email where Mr. Locke was asking for the documentation that our experts said they were supposed to have, and you saw him act as if what he saw when he asked for the documentation never existed. You were asked, one of the questions was about the limited partnership agreement. Their own accountants, this is Mr. Rizzi at DE 957. This is one of their own accountants. And you can see that in this area, he's basically saying, we followed the guidelines of the LPA or limited partnership agreement. If you believe that's GAAP, that's what you believe. That's what's in the agreement. That's what we said in our briefing materials, Your Honor. So I keep hearing these things from opposing counsel that this piece of evidence exists or that piece of evidence doesn't exist. Indeed, it does. And you're seeing it with your own eyes today. And this is exactly why the trial court committed the error that it did, because we have a large record here. We would hear about these things existing or not existing. You heard opposing counsel say that, for instance, there were investments that we're talking about that were showing up on the brokerage statements. Absolutely none of these investments where you see a quantity here on this particular document. It's DE 576. Not a single one of these was on a brokerage statement, Your Honor. And yet you just heard opposing counsel say the opposite. This is exactly why the error occurred at the trial court below, because of just this kind of thing. You just heard opposing counsel say that under our cases that there is an intentional conduct standard under our law with respect to gross negligence. Now, again, we alleged negligence, Your Honor, and the trial court, and this is at their appendix in their brief at Appendix 6. It's from the summary judgment argument, and this is the court. And I'm reading from line 5, and he said this to me. You alleged in your complaint that SS&C was negligent. And yes, we did, Your Honor. It's in there. We've quoted it in spades in our briefing under Haney, and in a recent case at the Supreme Court, Savino. It's not even if we mislabeled it, which I don't think that we did, but even if we had called it a securities fraud claim, it's what you allege. It's not the name or the label that you put on it. This is Pleasant v. Johnson that you see here, Your Honor. You just heard opposing counsel say that our gross negligence standard requires intentional conduct. They leave out the wanton part of the conduct every time, and so did the trial court, Your Honors. And that was what infected from the 12B6 ruling on, it infected this whole case. Here's Pleasant v. Johnson, our Supreme Court. We have described wanton conduct as an act manifesting a reckless disregard for the rights and safety of others. That's exactly right. And on our negligence claims, And on our gross negligence claims, Your Honor, we have plentiful, abundant evidence. You've heard opposing counsel spend a half an hour arguing facts, saying this contradicts that, and so on. You've seen smoking gun documents this morning that presented issues of fact. To the degree that they disagree with them or say shifting basis is okay, our expert said it's not. When you say recording something and you call it an innocent mistake, as the trial court did, and as you heard this morning, that's their position. A jury should be deciding those questions of fact, Your Honor, not a judge. The court in this case improperly substituted itself for the fact finder when a jury should have been resolving these questions on behalf of our clients, Your Honor. We appreciate your time today. Thank you very much.
All right, thank you, counsel. That will be the end of the open session for this case. Mr. Soar?
Yes, Your Honor. Do you want me to adjourn this and re-adjourn in closed session?
Yes, let's do that. Close this session and we'll open a separate closed session. Thank you.
Yes, Your Honor. This session of the North Carolina Court of Appeals is adjourned. And one moment while we go off and reset everything.
All right, so we're out of the live stream now.
And I've set the timer for 5 minutes with a 1-minute warning. And I will now open the closed session. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in closed session. God save the state and this honorable court.
Thank you. We'll hear from the appellant.
Your Honor, can you hear me? Thank you, Your Honor. In the trial court, we repeatedly argued that the materials in this case should not, most of them, if not almost all of them, should never have been marked confidential pursuant to the protective order that the trial court entered. It's a frequent occurrence in business court to enter these protective orders in these cases. And then what frequently happens and happened ad nauseum in this case was that the other side would mark virtually every document, regardless of how innocuous it was, as confidential. And so we would have to submit them on a sealed basis. We had multiple arguments at the trial court level over this, and quite frankly, can't spend all of our time arguing about whether something is sealed or not when based on good faith it was not supposed to be or marked confidential. Then finally, toward the end of the case, the court unsealed a number of documents, but not all of them. And once again, there is just a limited ability on our part to keep having these same arguments. One of the documents that I was going to show the court today was basically from a sort of teaching program that SS&C had, and it's very elemental. It did nothing but show the relevant accounting standard that they were supposed to follow. And as you probably know, when I asked the court to use it, I was told because it was under seal and because of everything being broadcast via YouTube and so on, that I couldn't use it. And it never should have been confidential to begin with, never should have been under seal. But again, how many arguments are you going to make over whether something is sealed or confidential when the other side did it? And we've got, in a case like this, of course, we've got the merits argument that we have to worry about. So we complied with the rules as we're supposed to. We've kept everything confidential, but we don't think that any of these documents merit overturning our open court's constitutional provision so that the public can see what happened here. And I will let you know, Your Honor, that I've got 3 cases pending right now in the business court. There is an awful lot of what's going on in the business court where the protective order is entered, things are marked confidential, things happen under seal, and the public is not hearing what happened. And in this case in particular, we believe this case has public interest and the public should see everything that happened and should see the reasons for it. And that's the reason for the open courts provision in our Constitution. So in our opinion, Your Honor, none of the documents that are in the record before the court should have been marked confidential, to at least to begin with. There are better and worse arguments among them, of course. I will concede that. But in the main, what's happened here is we've had to file things under seal that the plaintiffs certainly didn't want to have under seal, but we were obeying the rules. We were obeying the lower court's order and we were doing what we were supposed to. And in our opinion, the court should unseal everything, and the public should know what happened here, regardless of the way the court turns on the questions. Thank you, Your Honor.
Mr. Money, is there anything in your brief that is a direct excerpt from those sealed materials? I know there's a lot of references to those page numbers, but is there anything that is a direct reference that we need to be cautious of?
If we were supposed to file it under seal, we did. So those elements of it, you would be able to tell from that. But I know from just my attempt to use as an exhibit, the e-pace document, which it's akin to like a legal lawyer CLE, where their accountants were being trained to ask for documentation and told that they had to have it, bank statements and so on. I was not able to use that today because it had been filed under seal. I feel confident we cited to that in the brief, and I was going to show the court some of those materials today, and then was alerted that I could not because of their sealed status.
Thank you, sir.
Thank you, Your Honor.
If we propose to the appellee to review your appellant's brief, propose any necessary redactions of sealed information, and then, with your consent as well, on behalf of your client, we post that version of the appellant brief on the public docket, would you have any objection to that?
No, Your Honor. And I believe that something from the court, in essence, asking them to perform that function would be helpful. But if you look at that e-pace, the underlying part of the record where we're addressing it, I think you'll say, why on earth was this under seal? And I think it's because it's very simple. A jury could understand it. I mean, the reasons for it being marked confidential and being under seal, I don't think those are good ones. The counsel on the other side that argued the appeal today, in his defense, if you will, he wasn't the trial lawyer. So he wasn't the one that put the stamp on the document, and he'll probably be asked to defend it perhaps. But in any event, there are a lot of documents like that, but that's the one that stands out with me because I had wanted to use it with the court today.
Okay, thank you, counsel. We'll
Thank
hear
you.
from the appellee.
Thank you, Your Honors. But, suffice it to say, I disagree with some plaintiff's counsel's characterizations about the sealing applications in the court below or the conduct of the business court. But just in the interest of cutting through this, we are certainly happy to propose redactions to plaintiff's counsel's opening brief. I think there is a very, very, very limited amount of material that would need to be redacted, if any. In fact, I'd like to have the opportunity to review it more closely if that's acceptable to the court, but it may be that we can simply file it publicly. I will add the vast majority of the record in this case is unsealed. In fact, I think every document, with the exception of 6 submitted on summary judgment, we didn't seek sealing treatment for. So there are 6 summary judgment exhibits that are in the record on appeal that we do believe appropriately merit sealing. They deal with things like SS&C's policies, procedures, training, fee schedules, the type of competitively sensitive material that I believe is appropriately sealed, especially where, as here, I don't believe they have any significant impact on the outcome of any decisions in this case to date. So we would be happy to work with plaintiff's counsel, and I don't think there'll be any dispute here, agree to a redacted form of their opening brief that we could file. I'm of course happy to answer any other questions if there are, additional documents apart from plaintiff's opening brief that the court's focused on or would like me to address. But, if that will go some way to resolving this issue, we're absolutely happy to do that.
Thank you so much. I appreciate your willingness to cooperate with plaintiff's counsel potentially on that. Obviously, we vote in panels, so it's unlike a trial court where I can just say, yeah, we're good with that. So obviously, we'll have to take that under consideration, but I appreciate that concession and potential agreement.
That's an issue that I'm hoping we can make very easy. Not sure if there will be others, but we'll make that one as easy as possible.
Okay, well, thank you both for your arguments today, and we will adjourn this session. Mr. Soar?
Yes, Your Honor. This session of the North Carolina Court of Appeals is adjourned.
All right, we appreciate you appearing for this remote argument today, and as I tell